It was 11:30 on a Tuesday morning when I found the bright red envelope stuffed between my regular mail. The words "Final Notice" were stamped across it in letters so large they could probably be seen from space. Inside was a demand from the Riverside Estates HOA for $25,000 in accumulated fines for what they called unauthorized construction and property violations at my lakeside cabin. The amusing part was that my cabin sits 3.2 miles outside their jurisdiction on land my grandfather bought in 1964. By the time this whole mess ended 6 months later, their entire board would be standing in front of a county judge while their president got slapped with criminal fraud charges. My name is David Preston and I work as a structural engineer for a mid-sized firm downtown. I bought a modest house in Riverside Estates 5 years ago, mainly because it was close to work and had decent schools for when I eventually settled down. But my real sanctuary is the cabin on Lake Morrison that I inherited from my grandfather. Every weekend I can manage, I escape to that little slice of heaven where the only sounds are birds and water lapping against the dock. It is where I go to forget about permits and building codes and neighborhood politics. The trouble started when Karen Peton became president of the Riverside Estates HOA board. Karen was a former bank manager who had taken early retirement and apparently decided that running the neighborhood like her own personal kingdom would fill the void in her life. She wore power suits to weekend board meetings and carried a clipboard everywhere like it was a royal scepter. Within her first month, she had tripled the number of violation notices being sent out and started what she called proactive compliance walks where she would patrol the neighborhood looking for infractions. I first appeared on her radar when she saw me loading fishing gear into my truck one Friday afternoon. She marched over with her clipboard and asked in a syrupy sweet voice if I had submitted the proper vehicle modification form for the rod holders I had installed in the truck bed. I politely informed her that the truck was my personal property and the HOA had no authority over vehicle modifications. Her smile tightened and she made a note on her clipboard before walking away without another word. The next Monday, I received my first notice. It was not about the truck, but about excessive noise from construction activities at my secondary property. The notice claimed that multiple residents had complained about hammering and power tools disturbing their peace on weekends. This was particularly interesting since I had not done any construction at the cabin in over 2 years. When I called the HOA office to clarify, the secretary seemed confused and said Karen had personally filed a complaint based on her own observations. I ignored the notice, figuring it was some kind of mistake, but they kept coming. Every week brought a new violation notice about the cabin. Non-approved exterior paint colors, illegal dock extension, failure to maintain landscaping to community standards, unauthorized watercraft storage. Each notice came with escalating fines starting at $100 and doubling each time. The letters got increasingly aggressive with lots of legal-sounding language about liens and legal action. After 2 months of this nonsense, I finally drove to the HOA office with a folder full of documents. I spread out the property maps and tax records on the conference table and explained to Karen and 2 other board members that my cabin was located in unincorporated county land well outside the boundaries of Riverside Estates. Karen barely glanced at the papers before pushing them back toward me with a manicured finger. She informed me in a condescending tone that the HOA had recently expanded its area of influence to include properties that impacted the visual and environmental quality of the community. I asked her to show me where this expansion was legally documented. She said the board had voted on it in a special session and it was all perfectly legitimate. When I requested copies of the meeting minutes and the legal filing for the supposed expansion, she said those documents were confidential and only available to board members. She then stood up and announced that if I did not begin paying the accumulated fines immediately, the HOA would have no choice but to pursue aggressive legal action. The fines had reached $8,000 by this point, according to their creative accounting. I walked out of that meeting and drove straight to my attorney, Michael Harrison. Mike specialized in property law and had helped me with the paperwork when I inherited the cabin. He laughed out loud when I explained the situation and said it was the most blatant case of HOA overreach he had seen in 20 years of practice. He immediately sent a cease and desist letter to the board explaining that they had zero authority over my cabin and demanding they stop sending notices. Karen responded by having the board vote to impose a special enforcement penalty of $25,000 for what she called willful and repeated non-compliance with community standards. The letter informing me of this penalty was hand-delivered by a process server like I was being sued for murder. It stated that if the fine was not paid within 30 days, a lien would be placed against both my properties. She had clearly done her homework and knew I owned the house in Riverside Estates, even if the cabin was outside their reach. This was where Karen made her fatal error. She got greedy and impatient. Instead of waiting the full 30 days, she filed the lien after just 2 weeks. And she did not just file it against my house in Riverside Estates. She filed it against the cabin property, too, which required her to submit legal documents to the county clerk claiming the HOA had jurisdiction over that land. Those documents included a sworn affidavit that she signed personally stating that the property fell within the HOA boundaries. Mike called me the day the lien was filed, and he was practically giddy with excitement. He explained that by filing false documents with the county, Karen had committed felony fraud. This was no longer a civil matter between me and an overzealous HOA. She had involved the county government and made false statements on official documents. We immediately filed a motion to have the lien removed and requested an emergency hearing. While we waited for the court date, I did some research of my own. I discovered that Karen had pulled similar stunts at her previous neighborhood in Millerton Heights. She had been removed from that HOA board after trying to find a 90-year-old widow for having the wrong shade of beige on her mailbox. I also found 3 other property owners near Lake Morrison who had received similar threatening letters from Riverside Estates HOA despite living nowhere near the neighborhood. The hearing was scheduled for a Thursday morning in front of Judge Patricia Lawson. The HOA hired an expensive attorney from the city named Richard Blackstone, who showed up in a 3-piece suit looking like he would rather be anywhere else. Karen sat at the defendant table wearing her best powers suit with a pearl necklace and matching earrings. She had even brought a leather portfolio with gold embossed initials as if this was a business presentation rather than a legal proceeding. Mike presented our case with surgical precision. He showed the property maps, the tax records, the county jurisdiction boundaries, and then the fraudulent documents Karen had filed. He explained how she had knowingly and deliberately made false statements to the county clerk in an attempt to extort money from me. Judge Lawson listened carefully, occasionally asking for clarification on specific points. When it was the HOA attorney's turn, he tried to argue that there had been a simple misunderstanding about property boundaries. He claimed the HOA board had genuinely believed they had expanded their jurisdiction through a proper vote. Judge Lawson asked him to provide documentation of this expansion. He fumbled through his papers and admitted he did not have those documents with him. The judge then asked Karen directly if she had personally verified the property boundaries before signing the affidavit. Karen started to give a long-winded explanation about community standards and visual impact zones. Judge Lawson cut her off mid-sentence and said she had heard enough. She stated that the evidence clearly showed the HOA had no jurisdiction over the cabin property and that false documents had been filed with the county. She immediately ordered the lien removed and all fines dismissed. But she was not done. She scheduled a second hearing to determine if criminal charges should be filed for fraud and whether punitive damages were warranted. The second hearing took place 3 weeks later. By this time, the story had made the local news and the Riverside Estates HOA was in full damage control mode. 2 board members had already resigned and the remaining members were trying to distance themselves from Karen. Several residents showed up to testify about Karen's aggressive tactics and questionable fines. The 3 other Lake Morrison property owners I had found also testified about receiving threatening letters. The district attorney's office had opened an investigation based on the fraudulent documents. The prosecutor explained to the judge that Karen had a pattern of using her position to intimidate and extort money from property owners. They had found 17 other cases where she had imposed questionable fines that people had paid just to avoid the hassle of fighting them. The total amount collected exceeded $40,000 over just 8 months. Judge Lawson ordered the HOA to pay all my legal fees, which came to $12,000. She imposed an additional $50,000 penalty for harassment and attempted extortion. She referred the criminal case to the district attorney for prosecution and strongly recommended fraud charges be filed. Finally, she issued an injunction preventing Karen from serving on any HOA board in the county and requiring court supervision of Riverside Estates' HOA for the next 2 years. Karen sat frozen in her chair as the judge read the judgment. Her face went from red to white to an interesting shade of gray. When the judge mentioned potential criminal charges, her hands started shaking so badly she dropped her gold-embossed portfolio and papers scattered across the floor. The final blow came when Judge Lawson announced that the State Real Estate Commission would be notified since Karen still held a real estate license from her time as a property manager. That license would almost certainly be revoked. 6 weeks later, Karen was formally charged with 3 counts of felony fraud and 14 counts of misdemeanor extortion. She took a plea deal that included 2 years probation, 300 hours of community service, and $50,000 in restitution to be divided among all the property owners she had wrongfully fined. The look on her face when the judge read the sentence was pure shock, as if she could not comprehend how her little kingdom had crumbled so completely. She actually asked the judge if there had been some mistake because she was just trying to maintain property values. The judge stared at her for a long moment before simply saying, "Next case."